5 seconds to go. Start. There is yet another reason to decline the forced contention of the respondent. Stop. We would not have even perused annexures A1 to A8, which are statements of some of the victims recorded under section 161 and 164, CRPC, recorded much prior to the impugned judgment dated 20th April 2021, which, in the year 2019 itself. Stop. We do so solely to verify the verity of the finding of the High Court to the effect that such statements do not disclose anything suggesting knowledge of the respondent about the commission of the crime. Stop. In truth, those statements did mention about divulgation of sexual assault on them by victims to the respondent. Stop. We may hasten to add, at the risk of repetition, that such statements recorded under section 161 and 164, CRPC are inadmissible in evidence, as held in M.L. Bhatt's case supra and in Rajiv Kaurav's case supra. Stop. In the light of the circumstances available as above and in the light of section 59 of the Evidence Act, the High Court was not justified in bringing abrupt termination of the proceedings qua the respondent. Stop. The position revealed from the discussion above constrains us to hold that there is prima facie case against the respondent for the offence referred above and hence, the appeal is liable to succeed. Stop. Para. In the light of the decisions and the provisions referred above, the impugned judgment resulting in quashment of the stated FIR and the charge sheet throttling the prosecution at the threshold, without allowing the materials in support of it to see the light of the day, cannot be said to be as an exercise done to secure interests of justice, whereas it can only be stated that such exercise resulted in miscarriage of justice. Stop. Para. In the result, the impugned judgment of the High Court is set aside and the appeal is, accordingly allowed. Stop. Pending applications, if any, are disposed of. Stop. Para. A two-judge bench of this court dealt with the question as to the matters that could be considered by the High Court in quashment proceedings under section 482 CRPC. It was held therein that statements of witnesses recorded under section 161 CRPC, being wholly inadmissible in evidence, could not be taken into consideration by the court while adjudicating a petition filed under section 482 CRPC. Stop. In that case, this court took note of the fact that the High Court was aware that one of the witnesses mentioned that the deceased victim had informed him about the harassment by the accused, which she was not able to bear and hence wanted to commit suicide. Stop. Finding that the conclusion of the High Court to quash the criminal proceedings in that case was on the basis of its assessment of the statements recorded under section 161 CRPC, it was held that statements thereunder, being wholly inadmissible in evidence, could not have been taken into consideration by the court while adjudicating a petition filed under section 482 CRPC. Stop.